Good morning and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in Peckville, Pennsylvania, and I am right here each and every week at this time on this station to bring you, the landowner, the information you need regarding natural gas development. And as my good friend Dave knows, who listens to the show every Sunday morning as he makes breakfast with his children, I do not, I have not, and I will not ever represent oil or gas companies. I represent Pennsylvania landowners, royalty owner, property owners, and will not represent gas or pipeline companies. I represent landowners for gas lease negotiations, gas lease reviews, pipeline agreements, pipeline negotiations, reviews, royalty issues, unitization issues, breach of contract issues. Did the company breach your oil and gas lease or your pipeline right-of-way agreement or any other type of contract that you have with the company? Also doing more and more estate planning work. As a lot of clients are starting to and have been getting royalties, they're looking more at their estate plans and making sure that they have everything in place if, God forbid, something should happen. So doing more and more estate work as well. You know, I talk a lot about these and I have to continue to do it. The reviews and consultations, I do them all the time. If you are presented with any type of agreement for any type of oil and gas development anywhere in Pennsylvania, for the property in Pennsylvania, feel free to give us a call and ask and learn about the reviews and consultations. You can send me the information. We can do it by telephone. You're always invited to come to the office. I review the information. We say get on the phone or you come to the office. But I've done these with people in California, Alaska, Micronesia, Canada, Texas, many other states across the country where the people have ownership interest in Pennsylvania. So please don't be worried or concerned about distance. Give us a call and then learn what we do and see if I can help you. And if it works out, and it sounds like we can help you and I can help you, hey, let's do it. If it doesn't, hey, that's okay too. But don't be afraid to call. Learn about these services and what we can maybe do to help you and see if we're right for you. And you can always call the office, 570-307-0702. That's 570-307-0702. And I want to just touch on for a second, one of the things that I've been doing recently quite a bit is reviewing leases that are older leases. And when I say older, I mean, sometimes these are really old, but older can also be around the year 2000 to the year 2005 in that type of range. But again, anything older than that as well. But what I've been doing is landowners across Pennsylvania will say, hey, you know what? I think that maybe my lease is expired. Maybe my well, or I'm being held under this very old lease for year after year after year for shut-in, receiving shut-in payments or some other type of annual really small payment. And they say, you know what? I think that maybe my lease has been breached. So we'll look at that. I look at that a lot. And we found cases where we think that clearly the lease has terminated. And then we're going to look to take action when that occurs. So if you have an older lease, and I'll tell you, look, this is just one example, but I don't care where you are. There's like an older Allegheny lease that if you have one of those, be careful because it may have expired. May have. I'm not saying it has, but it may have. So if you think that your lease may have expired or you think the company may have breached your lease, give us a call, do a review and consultation, and I'll give you my opinion. And if we think it's been breached, then we talk about what the next step may be. But again, these reviews and consultations, if you're presented with a pipeline agreement, a multi-unit well agreement, I'm sorry to say this, but I really believe if you have a multi-unit well agreement and you're not giving me a call, you're not checking out this review and consultation service, I really think you're making a mistake. Been able to negotiate in these multi-unit well consent documents, and if you're not doing that and you're not being represented and you're not maximizing what I see as an opportunity, I'm going to tell you, in my opinion, I really truly believe you're making a major mistake because it's something that I believe can help you and potentially help you quite a bit. So don't be afraid to pick up the phone. I always say, put down the pen, pick up the phone, learn about these services. Even with the multi-unit well consent, do at least a review and consultation, and then decide to where to go from there. And I think in many cases, you may like what you hear, but again, we have to look at your case specifically. Also, one more point, I want to remind everybody again, and I know I keep hammering this because I'm only hammering these issues because they're really big issues. And one is lease ratification. If you are being asked to sign a lease ratification, you should be getting a review and consultation, whether through my office with me or somebody else who knows what they are doing. These lease ratifications, and are often called lease modification, amendment, and ratification. But when you see that word ratification, again, red flags should be popping up. Get a review and consultation from me or someone who knows what they're doing, and make sure that you understand what you're signing, because you literally could be giving up. I'm not saying this is in every case, but literally people are losing hundreds of thousands of dollars and even millions of dollars because they are signing ratifications to leases that they shouldn't be signing. And they don't understand why they're presented with the ratification. They don't understand the meaning and the effect and the impact, the future impact that executing that ratification is going to have on them. And unfortunately, they're only listening to the company's explanation as to, oh, hey, yeah, here, we want to go ahead and we want to develop and make you a bunch of money. Here's the pen, here, sign here. That's not what we should be doing, guys. Nobody should be doing that. Again, these are major commercial industrial contracts. Many of them are ultimately multi-million-dollar contracts, or at least multi-six-figure contracts. So we need to make sure that we're not entering into these lightly and not without all available best information to educate and guide us to make our best decision. As I say all the time, the radio show is not specific advice for anybody. The specific advice is always go out and get specific advice. But generally speaking, put the pen down and pick up the phone. Do not sign these documents without fully understanding them, understanding your leverage, understanding your options, and understanding how they may impact you in the future. And today, we're going to talk about a new lease form that's out there floating around. Well, and not just floating around, being offered to people in primarily Potter and Tioga, but maybe other places as well. And it's by a company called Eclipse. And this company, Eclipse, is sending out, it's Eclipse Resources PA, LP. There's a few letters there, but we'll call them Eclipse. We'll call Eclipse Resources. We're going to call them Eclipse. But they have an offer that's pending out there that they're submitting to people, mostly what I've seen in Tioga and Potter County. And I'm going to tell you, generally speaking, not specific advice, drum roll, I hate this offer. It's, in my opinion, generally speaking, not specific advice, a terrible deal for the landowner. Terrible deal. Terrible deal. And if you're offered this, and as an example, if we did a review and consultation, they usually take 1 to 2 hours, and that includes the review time and the telephone or in-office meeting, and I explain in detail all the different concerns that I have. Now, we need to look at your situation specifically, because it's not like I could sit there and play a recording and play that to every person that has an Eclipse lease, and they have all the information that they need. Just like if I could, I would just say, hey guys, tune in to last week's radio show where I talk all about the Eclipse lease. Well, no, I'm going to talk about the Eclipse lease. And remember, guys, regardless of who you're leased to, this is going to be relevant to you. I don't care who you're leased to. If you care about royalties and development, this is going to be relevant to you. So I can't even say, hey, go listen to last week's show, because I'm just going to talk about some general concerns with this document. Now, if you have 2 acres or you have 200 acres, the discussion may be quite a bit different. depending upon where your property is located. The detailed individual discussion may be quite a bit different. But generally speaking, I'm going to highlight some terms in this offer that are, to me, extremely concerning. Extremely concerning. And as always, it really concerns me that people are signing this, and I know darn well that they don't understand what they're signing. And as I always say, if you understand what you're signing, and you're content with what you're signing, and you understand it, and you elect to sign it, then you're making the right decision for yourself. When you have the information and you evaluate that information, you evaluate your situation, you are making the right decision if you sign. You're also making the right decision if you don't sign. And that decision is up to you. But the key is you have to get the information that you need, not the information that the company wants you to have. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Make sure you join me each and every week at this time for All Things Marcellus. This Eclipse oil and gas lease offer, and when I say that I'm sure that people aren't understanding this document, let me tell you this. The lease itself, the one I'm holding here, the lease with lease with addendum, 13 pages. The lease, before you even get to the addendum, consists of 10 pages. So you got 10-page document as a lease. There's a lot of words in these 10 pages, and a lot of them are terms of art to the industry, a lot of legalese, a lot of contract language, and we're talking, again, 10 pages of this, and I can't begin to think that the people signing this are understanding all the information in this document. Now, look, I'm not crazy. I understand that people sign documents that they don't understand everything in all the time. But, remember again, this is something different. These are major contracts that are going to apply to you and have an impact on you for the rest of your life, most likely. And in fact, probably the rest of your children's lives and even into your grandchildren. So it's so critical that you do this right, because rarely do you get a second bite of the apple, another opportunity. So you have to do this right the first time. And so when you get a 10-page lease that's extremely complicated, and you say, oh, okay, I'm going to listen to what the person who wants me to sign this lease has to say, where their employer is going to benefit from this lease, and it is a negotiation. Going into Dave's car dealership and say, oh, hey, Dave, tell me about this car. And Dave tells you, oh, it's the greatest car in the world. It has every single thing in the world. This car is worth $50,000. Go ahead. Here it is. Here's the keys. Give me your $50,000. Oh, okay, Dave. Okay, here's $50,000. Let me go. No, you're going to ask questions. You're going to say, wait, that's a little high. You're going to try to do something about the price, assuming you even want to buy that car. But somehow in gas leases, in pipeline agreements, in these major commercial industrial contracts, we have people who use less effort than what they do in, say, purchasing a new or used car, who get less information of something that's so complicated. And then we see how companies, we see the lawsuits, we see the disgruntled landowner, royalty owner, who's very upset about their royalty payments aren't what they were told. They were told something by the company or company landman, and now it's not happening. Let me tell you that in my experience, that's a pretty regular occurrence. Now, that's my experience. Maybe somebody else has different experiences. So the key is to understand in a truthful way what is most likely going to occur and how it's going to occur under these documents. So you want to understand this contract that you're negotiating. You want to understand the good and the bad. And you want to understand how this thing is written with loopholes that may really come back to haunt you. And certain terms, certain requests that may be granted can increase the value of the lease. Your royalty calculation method, if you can change how your royalties are calculated, that can increase your lease value by easily 25% over the lifetime of the lease. Easily. But I would not expect the company employee or company representative to explain to you how you can increase the value of this lease, if you can, by 25% or more, depending upon each situation. And again, this is just one point. And I don't want to get too detailed in this one point, but I will say that changing royalty calculation can be an enormous benefit to you, the landowner. And I'm going to explain why after this next break, because again, this lease offer by Eclipse offers the lowest possible royalty allowed in the Commonwealth of Pennsylvania, the lowest that you can possibly give a person. Then they chalk it up clear full of deductions upon deductions. And if you're getting 12.5% and you wait till you hear this deduction language, just think of the impact that's going to have on your royalties, not just for a month or two, but for the lifetime of the lease. For the lifetime of the lease. So you better darn well be aware of it, and you better know, can you change it? And you better know, if you're going to sign it, what you can expect in the future. And I'm going to tell you after this break. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember to join me each and every week at this time on this station for All Things Marcellus. And a couple items to highlight. If you have a multi-unit well consent request, a document, multi-unit well consent, I'd really encourage you to give us a call and find out about reviews and consultations. I really encourage you. I really think we can help you. Also, if you have a ratification, I cannot say this enough, and I'm going to maybe say this every show forever until I stop seeing ratifications, but we got to stop signing ratifications. You got to get assistance. You have a ratification, a lease ratification, oil and gas lease amendment modification ratification. Give us a call, learn about reviews and consultations. These can be big, big deals. Finally, Tioga County, my friends in Tioga, SWEPI, shut in, 8 years, 7 years, you're shut in. There's no royalties. You're only getting shut-in payments. I would really like to hear from you because we are looking to make a move. And I am investigating. I have new clients in this issue, and we're going to start pushing it really, really soon. So I want to hear from you, and we want to see if we can help you. So if you're frustrated, and you should be, because you didn't enter into a gas lease in 2005, 4, 3, 2, whatever that year was, thinking you'd be sitting there in 2018 and not seeing any production. That wasn't what you thought, and we need to do something about that. So give us a call, 570-307-0702. Put the pen down, pick up the phone, 570-307-0702. I'll be right back after this break, and you're going to hear some scary language. What else is new? I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, you can always give the office a call anytime, learn about reviews, consultations. Of course, I will not work for oil and gas companies or pipeline companies. Give us a call, 570-307-0702. And I just want to quickly highlight multi-unit well requests, also oil and gas lease amendment modification ratifications, and Tioga County, SWEPI, or if you've now been assigned to another company and they're sitting there, you're shut in, you're getting no royalties, you're getting an annual shut-in payment and nothing else, and you've been shut in for at least 7 years, 8 years, 9 years. I really want to hear from you. I want to see if we can help you out. Give us a call, any of those scenarios and many others. 570-307-0702. Remember, keep listening every week to All Things Marcellus. And another thing, check out the websites. If you haven't been to the websites, I really encourage you to go there. pagasleaseattorney.com, pipelineattorney.com. Really go there. Just real quick on pipelines, because I know if you are signing a pipeline agreement without getting help from somebody working for you who knows what they're doing, I'm going to tell you this, you're making an enormous mistake. I see pipeline agreements negotiated to increase compensation that we're involved in, that I'm involved in, all the time. We have to stop having our landowners leave tens of thousands and even hundreds of thousands of dollars on the table because they picked up the pen instead of the phone. We have to stop that. It kills me to see people signing. Oh gosh, I don't even like to say this number of $7 a foot. That's insane to me. Like, that really to me is crazy. It's crazy to me. I've never, to my knowledge, had a client sign at $7 a foot. I don't believe I've ever had anyone sign at 10 or 12 even. I think way back in the day, we did some $15 a foot. And every once in a while, there's a scenario where it's a short line going right to a well site on the pad that we've done agreements at $15 a foot. But I'm going to tell you, as a general rule, in my opinion, $15 a foot is not enough. And the only reason Tioga, Potter, Western PA, the only reason why companies are throwing out these, in my opinion, garbage per foot payments are because they've been able to persuade people, like they have in other places in the past, that this is a good deal for you, the landowner. And the reason that's happening is because landowners are simply listening to the landman or the company employee, and they're also listening to promise of future riches, future money. Well, let me tell you, this is not the first time this song and dance has been played and performed. So we need to learn from this, and we need to understand what our negotiation leverage is. I don't care what they tell you. When they say, well, this is all we pay, it does not make it true. Words coming out of a person's mouth are not all true. And I think we know that. We know that in our lives all the time. But yet somehow, when confronted with a contract or presented with a contract from a Fortune 500 company, from a multinational company, we then start to believe their employees and their representatives and their agents, but yet we doubt other things that we may hear at the gas station, at the diner, at church, but yet we buy into what this other stuff is being told to us. And I can only think it's based mostly on the promise of riches. Like, oh, hey, here, pen, sign, money. Well, it doesn't always work out that way. And many times, people leave tens of thousands, hundreds of thousands, and sometimes, and more often than you would think, when you talk about the life of these oil and gas leases, depending upon your acreage and location, literally millions of dollars that could have been obtained if you would have done your due diligence, got somebody, talked, did a review, consultation, got somebody working for you, understand the contract, understand your leverage, and negotiate to maximize your position. And that's what we do all the time. And that's what I do all the time. And if we think we can't do it, then, I tell you, hey, look, here's the situation. Here's your leverage. You have really great leverage. Boy, your leverage is really bad. Here's the reasons why. But who should be assessing your leverage? Somebody working for you, not somebody working for the gas company, the pipeline company. These pipeline agreements that I am seeing people sign, again, we're seeing a lot of these now come up in Tioga and Potter, but they come up everywhere. They're bad agreements, in my opinion. Some of them are horrific, but people are still signing them. And the reason why, I have no doubt, is because people are uninformed, or they're relying and believing and taking the word of the company side. And maybe the company tells you everything that's true. However, they're only telling you what they want to tell you. What they want to tell you. What are they omitting from this discussion? Are they saying, oh, by the way, you don't have to sign this. By the way, we're really in a pinch and we have to come across your property. And by the way, if you demanded $60 a foot, $100 a foot, $80, pick a number, we'd end up having to probably pay that because we're really in a pinch and we need to do this. Your lease doesn't allow it. We have contracts with these gas companies and we need to get this gas to market. Are they going to tell you that? I don't think so. So you need to do some background work. You need to get some assistance. You really need to do that because you might be missing out on literally tens of thousands or hundreds of thousands of dollars. Then you might be granting far more authority than you ever know. And normally, in my experience, when I do reviews and consultations with pipeline right-of-way agreements, it's almost always that the person thinks that, oh yeah, they only want one line, or maybe they want two, and this is what they're going to do. And why does the landowner think that? Because that's what the company landman told them. But the documents say something different. And later on, when the third line goes in or an above-ground facility goes on the property, and then all of a sudden it gets fenced, and now in the middle of your field or in fairly close proximity to your house, you have a valve site, which is all fenced in, which is going to be there for the next century, let's say. And you had no idea that could occur. You said, wait, company, you can't do this. You told me it was going to be one or two lines. Nothing above ground. This is what it was going to be. Well, then all of a sudden that landman's gone. And now you got a guy from the company saying, well, you signed the agreement. Here it is. We're allowed to do it. You shouldn't have signed the agreement, or you should have gone to an attorney and found out what this meant. Because almost all of these agreements have language that says, look, anything that and it doesn't say exactly landman, but anything that the company representative, employee, contractor, all those types of things, what they say isn't part of the contract. What's part of the contract is what is written down on the contract. So if my contract, that the contract presented to you and you signed, says that they could put in an unlimited number of pipelines, but the landman told you only one or only two, those statements do not matter. What matters is the fact that on that piece of paper, on that contract, on that pipeline right-of-way agreement, it says that they can have an unlimited amount of lines. And now you're stuck. That's a very elementary example. But we got to make sure two things. You're maximizing your money, and you're protecting your property, and you're limiting future activity. I have multiple files that I'm working on right now where my clients are in an outstanding position, because when we did the original pipeline agreement, we put in restrictions that have limitations on what the company could do in the future, and now the company wants to do something in the future, and they don't have the right to do it because we did a good job previously. Now they need permission, and now we can either say no, or the landowner, the client, can negotiate for more money. And they're pretty happy about that. And that's the type of situation that you want to be in. You want to sign the best possible oil and gas contract. Then you want to make sure that as you go forward, you're taking advantage of every other opportunity. And remember, it's never too late. If you sign a bad lease and you're given a pipeline agreement, put down the pen, pick up the phone. It's never too late to start making good decisions. Never too late. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, you can always call the office, learn about reviews, consultations, multi-unit wells, shut-in issues, ratification, any and all oil and gas-related representation, 570-307-0702, 570-307-0702, regardless of your location. Give us a call, see if we can help you out, and keep tuning in each week to All Things Marcellus right here at this time on this station. So, got a little sidetracked there. I want to talk now about the Eclipse lease, but the first point I'm going to do before I dive into the royalties in the next segment, I want to talk about, I'm saying ratifications. I'm talking about people being shut in for 7, 8, 9 years or more and not getting royalty payments, but instead getting these yearly shut-in payments, or maybe a delay in marketing, but these yearly payments, mostly shut-in. Well, I want to read a provision from this Eclipse lease. And what I want to tell you, and I've mentioned this before, if you think there's an issue with your lease, if you think, hey, I've been shut in for 8, 9 years and this is not right, and you get a new shut-in payment for yet another year to be shut in, if you think you have a claim, if you think you want this reviewed, you want to see if you have a claim, you would not want to cash that shut-in check. You want to contact an attorney who knows what they're doing. You can always give us a call, 570-307-0702. But you want to contact an attorney, let's say have a review and consultation to find out, should you cash the check? Do you have a claim that your lease is terminated? Do you have a claim of breach? And you're going to be in a much, much better position if you do have a claim, if you haven't cashed that check. And here is an example. Now, rarely do you see this spelled out like this. But when you're Eclipse and you send somebody a 10-page lease, it gives you a lot of information that you can write down. It's like a book. So here's the language. It says, as a result of lessor, being the landowner, the royalty owner, as a result of the lessor accepting a payment, and this payment could be shut in or these other payments, it says that lessor and lessee, meaning landowner and company, stipulate and agree that it is deemed for all purposes that all such payments have been timely made when due, regardless of if the payment is timely paid when due or any time after it has become due. Now, that's like a word salad, but the point is watch out cashing checks. Watch out cashing checks. Now, this isn't individual or not. This is not specific advice to say, hey, everyone stop cashing checks. I'm not saying that at all. What I'm saying is, generally speaking, if you feel that you have a claim that your lease has been breached, that it's terminated, that you've been shut in too long, put the check to the side, pick up the phone, do a lease review consultation, see if you have a claim. But don't cash the check when you think there's an issue and then call. Put the check to the side, call, get an appointment, get a review consultation. Let's check it out, and let's see if you have a claim. Let's see. But don't cash the check first. Now, with that said, if you just cash the check and you're shut in for 8 or 9 years, I still want to hear from you. But if you're getting a check or you're about to get a check and you think there's an issue, generally speaking, you shouldn't be cashing the check until you determine if there's an issue. Because in all of these cases, when we find an issue and I talk to the company, I say, hey, you can't shut this guy in for 8 years under this type of lease. And the company says, well, he or she's been cashing the shut-in checks for the last 8 years. Well, that's the first thing they're going to say. It's not the end of it, but it's another hurdle or obstacle. So if you think there's an issue, take a break from cashing the checks and find out if there is an issue. All right, we're up against it here. We'll make sure Dave's not burning his eggs or pancakes or whatever he's up to, so we'll take a break. And when I get back, I'm going to talk about this royalty language. And, as usual, I'm picking this out because it's really bad. Really bad, and I'm going to explain when we get back. You're listening to All Things Marcellus. Join me every week at this time on this station. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Make sure you join me each and every week at this time on this station for All Things Marcellus. And in case you didn't know, I've been doing the show for over 8 years now, or in 8 years. We started in 2010. So we're not done. And if you missed this week's show or any show recently, you can go to the websites at pagasleaseattorney.com, pipelineattorney.com. Again, if you got a pipeline agreement, or you're presented with one and you're not going to pipelineattorney.com just to get information, what are you doing? Go check it out. Whether you ever call or get representation, hey, look, I'd always want to hear from you. But if you never call, just go look at it as a resource, as a general resource of information. Pipelineattorney.com, pagasleaseattorney.com. And today's radio show will be up and available tomorrow, Monday, on the website. So make sure you check those out as well. So, okay, let me get into this Eclipse lease offer. I'm going to focus on this royalty provision, this segment. And I'll tell you, I need a bigger segment because this is an awfully big royalty provision. But what's funny is the actual initial royalty provision, not that big. But then you get into the definitions provision, and that is enormous. So let's talk about it. So gas. Now remember, this is a lease that's paying 12.5% royalty, the lowest possible royalty allowed by law. If you are considering signing for 12.5% royalty, in my opinion, there should be a good reason. I am not saying that there aren't times where people should sign for 12.5%, but I'm telling you very clearly, generally speaking, you should be very, very slow to sign an oil and gas lease for 12.5% royalty. Very slow to do that. And if you do, and you're going to sign for 12.5 royalty, there needs to be, generally speaking, a reason that you're doing that, because that is the lowest possible royalty allowed by law. Then, on top of that, so this lease at 12.5% royalty starts off as being unattractive. Then, but not necessarily that in some cases you don't do it, but this is a major strike against it. Major. Most leases that I see offered are at minimum 15% royalty. That's my experience, 15%. So when I see 12.5%, I immediately say, okay, there needs to be some reasons that a person, the client or landowner, a royalty owner should be entering into this agreement. So we're going to investigate that. So this particular lease is offered 12.5% royalty. Now, I'm not going to talk about it now, but I'm going to say this. It's not offered a bunch of bonus money either. So you got two enormous strikes against this lease. Well, let's dive into, all right, 12.5% royalty. Maybe for some reason I feel that this is something I really need to consider. We know, because we listen to All Things Marcellus each week, that there are two really big components of royalty. One being the percentage, which is really easy to figure out, 12.5, 15, 16, 18, just simple numbers. The other is the royalty calculation method. You can easily get 12.5% royalty and have a very favorable royalty calculation method to you, the landowner, and that lease be worth more than an 18% royalty with very poor royalty calculation towards your favor, meaning very strong for the company, bad for you. I would easily rather have 12.5% royalty with royalty calculation language that I drafted than what I'm about to read to you from this Eclipse lease. And so the lease itself says, okay, on gas, here's how we're going to pay royalty. And it's literally one sentence. It says to pay lessor, and lessor is the landowner, on actual volumes of gas sold from said land, an amount equal to 12.5% of the amount realized by the company, computed at the wellhead. So that's saying that they're going to give you 12.5% royalty based upon the, and these are key words, amount realized at the wellhead. Now, the question then becomes, what does amount realized mean? Well, let me tell you, the words amount realized have been a source and have been interpreted in a lot of litigation across the United States of America. So this is a very important term. You better darn well know what that means. So it goes on, though, and says, next paragraph is definitions. It goes on, and here's what it says. I'm going to read some. As used in this lease, the term net amount realized by lessee computed at the wellhead shall mean the actual proceeds received by the company from the sale of the oil and gas after deducting any taxes minus post-production costs incurred by the company or its affiliates after the wellhead. As used in this lease, let me back up. So this says, remember they said 12.5% of the amount realized by lessee computed at the wellhead. This then says that that statement means that they will pay you from the sale of oil and gas after deducting taxes, then minus post-production costs incurred by the company, the gas company, or its affiliated companies after the wellhead. That's powerful stuff. Now, again, I'm not saying that in cases this can't be agreed to, but you need to understand what that means. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Okay, next sentence. As used in this lease, the term post-production costs shall mean all costs and expenses of A. Treating and processing the hydrocarbons. Separating liquid hydrocarbons from gas other than condensate separated at the well. Then it goes on to letter C. Transporting hydrocarbons, including but not limited to transportation of oil from the wellhead to any storage tanks and from such tanks to market, or of gas from the wellhead to any processing plant or other production or treating facilities, or the market pipeline to the point of sale. Then it says, and letter D, compressing gas for transportation and delivery. Remember, these are all post-production cost deductions. Letter E, metering hydrocarbons to determine the amount of gas sold and or the amount used by the company. Now, that seems bad enough, but now I'll tell you that, look, again, in some cases, you're not going to be able to change that. But here, that's bad, but it's about to get, it's like you're walking towards this edge and it's bad. And then here comes the final step. And that's going to be letter F. But then as you're falling down, you're going to hit a rock, and that's going to be letter G. So here you go. You're at the edge of the cliff, and here's the next step. That the company can also deduct sales charges, commissions, and fees paid to third parties, whether or not they are affiliated third parties. Again, they can deduct sales charges, commissions, and fees paid to third parties, whether or not those parties are affiliated with the gas company. They can make these deductions in connection with the sale of hydrocarbons. So again, now we're falling down. We've stepped off the cliff. We've now allowed the company to deduct sales charges, commissions, and fees paid to third parties, including companies that they are affiliated with or even own. That's what you're agreeing to. Now, are those reasonable? Who knows? But that's what you're agreeing to. So now you've just fallen off the cliff of deductions. And as you go flying down the cliff, there's some more rocks that are going to pop out and drill you. The first big thud is letter G, and that is that they can also deduct any and all other costs and expenses of any kind or nature. Boy, that's broad language. Incurred in regard to the hydrocarbons or to the handling thereof by the company, the lessee, the gas company, or its affiliates after the wellhead. That, ladies and gentlemen, is very concerning. But again, we're still falling off of this cliff because we're about to hit the ground now. And boy, this is going to hurt. Lessee or its affiliates. So the gas company or its affiliates may use its or their own pipelines and equipment to provide treating, processing, separating, transportation, compression, and metering services. So this is saying that the company themselves or their affiliates may provide these services, or they could hire other companies to do it. But if the gas company themselves or their affiliates uses its or their own pipelines or equipments, post-production costs shall include, without limitation, reasonable depreciation and amortization expenses related to such facilities. You just hit the ground, and now there's one last thing. Together with the company's or its affiliates' cost of capital and a reasonable return on its or their investments in those facilities. You have no life left in you at this point. You're on the ground. You're smashed. I mean, this royalty language is about as bad as it gets. So this lease document, this is all my opinion. This is not specific advice. This is my opinion. This lease document says we're going to give you the lowest possible royalty allowed in the Commonwealth of Pennsylvania. Then we're going to deduct virtually every possible charge that we can legally deduct. Then they can use their own pipeline equipment, or their affiliates can use their pipeline equipment, and the post-production charges that they charge you can include without limitation depreciation, amortization expenses, and its affiliates' cost of capital and return, a reasonable return on their investment for those facilities. Again, that is to me outrageous. And this is something that I'm starting to see in other agreements. This is something we need to address. And I'm not going to go into too much detail, but I'll say this, that in cases it can be addressed. So when you're thinking about future royalties and they say, oh, you're going to make you rich, here's the pen. No. Put the pen down, pick up the phone, find out what does this language mean. And at 12.5% royalty and all these, what I would call kind of regular deductions, then we add in this type of reasonable return on investment and depreciation costs and expenses. And remember, when you're out there and you're getting this type of lease, look who owns the pipeline company. If you got a lease like this and the company who gives you the lease also owns the pipelines, or their affiliated companies do, think about the impact that can have on you. And that may change your thought on whether this 12.5% lowest possible royalty allowed in the Commonwealth of Pennsylvania, when combined with these deductions, may make you hesitate or not sign now or negotiate the change. And that's where you need really, really specific advice. I'm up against it. And here's what I'm going to tell you. We've got one more segment, and I'm going to talk about the final, it's not the final, but the other big whammy in this. You say, well, okay, well, they cheat me, I'll sue them. Well, wait till you hear what you can do. Wait till you hear what your limitations are. If you feel they're cheating you and you feel that you have a great claim and a valid claim, wait till you hear how you're limited and what you can do. I'm going to explain that when I get back. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Join me each and every week at this time on this station. Give us a call. Learn about representation, reviews, consultations, 570-307-0702. I'll be right back. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember to join me each and every week at this time on this station for All Things Marcellus. You miss any of today's show, go to the websites, pagasleaseattorney.com, pipelineattorney.com. Today's show will be up and available Monday morning, as many hours of shows are available on the websites. So I want to jump back into it because I have another short last segment. But another little funny thing that I had to cut out. I got so fired up in this last segment going on over this royalty language, and I just, it says deductions weren't enough. Then they got to start throwing in depreciation, amortization, and reasonable return on capital investment. So I got a little bit fired up. So I'm going to tell you, I'm covered in coffee as I sit here now, but that's not going to stop us. We're going to keep going. Because I got so fired up. It just drives me crazy. And I know people are signing these leases and have no idea about it. And I'm saying that I'm not telling you that you don't sign these leases, but boy, if you're going to sign them, you better know about this, and maybe you don't sign because of it. And this is not specific advice, but boy, there should be a lot of reservation. There should be a lot of concern. There should be a lot of study put in before you agree to a 12.5% oil and gas lease royalty with unlimited deductions, which also include depreciation, amortization expenses, and potential cost of capital and reasonable return on investment for not only the gas company, but their affiliated companies. So you are now we talk about, remember, two parts of royalty, the percentage and the calculation. This royalty calculation, this formula of calculation is not good for you. And in fact, it's terrible for you. Very good for the company, not good for you. So when you're going to sign, if you're thinking of signing for 12.5%, lowest royalty by law, combined with about as bad of royalty calculation as I've seen out there, there better be a reason that you're doing that. You better know why. And if there's not drilling coming right now and there's not a darn good reason to do it right now, you may want to wait, because offers can go up, offers can go down. But you need to look at where your offer is and see, well, it can't get worse than 12.5% royalty. I'm telling you guys, it cannot get worse. No matter what, doesn't get lower than 12.5%. Then you talk about the deductions. And look, many people sign leases with deductions, and many, many times we can't change it. But all deductions aren't the same. Transportation costs using a pipeline is one thing. Then we get into return of capital, sales charges, all of these other issues, affiliated company expenses. Those are really scary. So you may say, well, look, if the company cheats me, I'll file a lawsuit. That's why there's courthouses. That's why there's judges. I'll file a lawsuit, and I'll go after them for cheating me. Well, guys, in a 10-page lease, there's going to be a lot of bases covered. And remember, we're talking about this Eclipse lease. In 10-page lease, they cover a lot of bases. And one of those bases they cover is what happens in the event of a lawsuit. And here's what happens. You have to go to arbitration. You don't go to court, you go to arbitration. You may say, well, I hear arbitration is good. It's quicker. That's what the company tells me. Well, of course, the company tells you that because they want you in arbitration. That is why it's in the body of their lease. They don't just put things in the lease because they're beneficial to you. They put them in the lease because they want those things. They want mandatory arbitration. They want mandatory arbitration. As a general rule, you absolutely do not want arbitration. Again, as a general rule, you absolutely do not want arbitration. You're listening to All Things Marcellus with me, attorney Doug Clark of the Clark Law Firm. So, the deduction language is horrible. And you say, well, all right, if they cheat me, I'll sue them. So now you think they're cheating you. Years into the future, they're cheating you. So, okay, I'm going to sue them. Then you find out that your only recourse is mandatory arbitration. Then you find out, because you didn't read this or understand it before, you find out that the arbitrator, that there's going to be one arbitrator, and this arbitrator has to have at least 10 years of experience in oil and gas law in the Commonwealth of Pennsylvania. And I'm going to tell you, aside from a few people on our side, the landowner side, the vast majority of attorneys or potential arbitrators that have 10 years or more experience in oil and gas law in Pennsylvania are not going to be people who represent landowners. They are going to be people with very close ties to the industry who are, generally speaking, probably going to be much more inclined to rule for the industry and the company than you, the landowner. Again, these companies are not stupid. Let's throw in mandatory arbitration. Let's require that the judge or the arbitrator has to have 10 years of oil and gas experience. Oh, and the arbitration has to be conducted in Pennsylvania, State College, Pennsylvania. This is all thought out, because if you sue them and you say you cheated me and you're cheating everyone else, you're not going to be able to bring a class action, so you can't group together. So unless they're stealing a lot, you're not going to bring a case because it's going to be too expensive to bring. And then you have to bring it in arbitration with an arbitrator or judge, so to speak, who's going to be 10 years of oil and gas experience, almost certainly favorable to the company side. So I got to wrap this up. This is a 10-page lease, and we're just scratching the surface. Eclipse lease. You need specific advice. Put the pen down. Pick up the phone. You're listening to All Things Marcellus with me, attorney Doug Clark of the Clark Law Firm. You can always give us a call. Love to see if we can help you. 570-307-0702. 570-307-0702. Remember, landman works for the company, not you, the landowner. Put down the pen, pick up the phone, stop signing bad agreements, and have a great, great week, everyone. See you next week.